Hi there, I hope you're doing great. My name is Mutiaba Conrad, a lawyer by profession and also a private law tutor. And today I'm basically going to be taking you through criminal law again, and we're going to be looking at the topic of assault occasioning actual bodily harm. But before we start on our class, I encourage you to subscribe to my channel. Just below there is a red button. Just click on it and subscribe. Also turn on your notification bell, and then also like and share this video with your friends and colleagues. So basically today we are going to be looking at that offense of assault occasioning actual bodily harm. And in our class, we are going to be first of all defining what that offense is about. Then we'll also be looking at the various ingredients of that offense. We'll also proceed to look at the actus reus and the mens rea of the offense. And then we'll also make an analysis of the various case law and also the legal framework within which the offense operates. But then also finally, we'll also look at the defenses that are applicable to that offense and also generally to the offenses against the trespass of the person, including assault, which we earlier looked at, and then assault occasioning actual bodily harm and also grievance harm. So all these defenses are going to be looked at in this video, which also apply to those three torts as discussed. So let's start right away with the definition of what amounts to assault occasioning actual bodily harm. And basically, when we talk of assault occasioning actual bodily harm, this includes hurt or injury calculated to interfere with the health or comfort of the complainant or the person who takes the case to court. Authority for that position, I encourage you to look at the case of Miller. It's a case of 1954, volume 2, Queen's Bench, page 282. That case is authoritative on that definition. So let's now quickly proceed to look at the law. This offense, what is the provision of the law that provides for the same? I encourage you to look at section 236 of the Penal Code Act of the Republic of Uganda. It provides for that offense. And having known the law that provides for that offense, let's now proceed to look at the ingredients of the offense. What must prosecution, what must the state prove for them to succeed under this offense? So the first ingredient of this offense is that there must be an assault on the victim. This is really very important. And secondly, the assault must have occasioned actual bodily harm to the victim. And then lastly, the accused must have occasioned the act that is actually being complained of. So those are the three ingredients. We are now going to proceed and then we examine them. Actually, those three ingredients were clearly laid down in the case of Uganda versus Gabon and two others, Criminal Appeal number 5 of 2015. Let's now proceed to look at what courts have held on the offense of assault occasioning actual bodily harm. So I'll invite you to look at the case of Ara versus Chow Fook. It's a case of 1994, All England Reports, page 552. And in this case, basically, the Court of Appeal held that the word actual from the offense, which is assault occasioning actual bodily harm. So the Court of Appeal was trying to say that that term actual means the injury shouldn't be minor, though it need not be permanent. So when we talk of assault occasioning actual bodily harm, here we exclude minor injuries, something like a scratch, maybe a slap. Very minor injuries may not really suffice under this category of offenses. So here what we are looking at is injury, okay? Or we are looking at bodily injury, or it could even include psychiatric injury, which is of a substantial nature. Those that are not of a substantial nature, those would definitely fall under assault. Now let's proceed to examine the second ingredient a little bit more, and we are saying that actual bodily harm is capable of including psychiatric injury, but it excludes emotions such as fear, distress, or panic. So fear, distress, and panic, those ones are not covered under the offense of assault occasioning actual bodily harm. But it's also important to note at this juncture that assault occasioning actual bodily harm can actually also include psychiatric injury. So here we are not only looking at the physical injury, but we are also looking at the psychiatric injury that may damage or injure someone's emotional or mental state. Of interest as well, I encourage you and invite you to look at Section 2 of the Penal Code Act, which actually attempts to define what harm is. And it goes on to state that harm is defined to include any bodily hurt, disease, or disorder, whether permanent or temporary. That's really very, very important. So please go and look at the Penal Code Act and also look at Section 2. It is very authoritative. Then also I encourage you to look at the case of Francois Chiza versus Uganda. It's a case of 1983, HCB, page 12. In that case, in summary, court held that mere loss of a tooth cannot amount to grievance harm. So court here was trying to surely give an example, saying that no, mere loss of a tooth, in the opinion of court, it did not amount to grievous harm. Let's now proceed to look at the actus reus and the mens rea of this offense of assault occasioning actual bodily harm. So the actus reus of assault occasioning actual bodily harm consists of the application of unlawful force and thereby causing harm to the body of another. So the moment there is that application of unlawful force, then that amounts to the actus reus of this offense. Then the mens rea of this offense will be proved by showing that the accused either intentionally or recklessly applied unlawful force, thereby causing harm to the body of another. So basically, that is what you'd have to prove for you to satisfy court. Of course, do not forget the burden and standard of proof in criminal matters. And of course, the standard is beyond reasonable doubt. And then the burden definitely lies on the state to prove their case on that standard. So having looked at the actus reus and the mens rea of this offense, let's now proceed to look at the defenses. What defenses would an accused person, what defense would they raise while in court for them to not be liable for this offense? So the first defense is consent. Okay, consent. So the moment the complainant consents to being assaulted, or if they consent for the act occasioning the actual bodily harm being committed on them, then that can be, or rather that can work against them, and it can be a defense that is raised by the other party. Authority, I encourage you to look at Section 224 of the Penal Code Act. When you read that section, it negatives criminal responsibility arising from surgical operations performed in good faith and with care and skill. So in case you went in hospital for an operation and a doctor, in trying to operate you or to treat you, they occasion actual assault, or they assault you in a way that actually commits harm on you, they can raise the defense of consent, and it's provided for under the Constitution. But of course, such persons are liable for the excess force used. So in case the doctor or the medical practitioner goes on to use excess force in treating you, then even if you would have consented in the beginning, but excess force that is not proportionate or that is not necessary, such a medical practitioner will be held personally liable. Again, look at Section 225 on the aspect of liability for excess force that is applied in such circumstances. Let's now proceed to look at the second defense, which is games and sports. And in case the assault is occasioned in due course when you're playing a game, it could be football or netball or any other sport, then the other party can always raise that as a defense, and authority for that position can be found in the case of R versus Kone. It's a case of 1882, volume 8, Queens QBD, page 534 at 539. And in that case, court held that prize fights didn't amount to assault. So here court was trying to say that if people are in a boxing ring or in such a fight, and it's a professional fight, provided it's professional, it's governed by certain rules and regulations, then assault that is occasioned during that course cannot amount to an assault in the legal sense. Also of interest, I encourage you to look at the case of Attorney General. It's a case of 1981, Volume 2, All England Law Reports, page 1057 at 1059, where court held that where parties do not have gloves on, these are the fighting gloves, okay, this would amount to assault. Again, this is what I was talking about, that the fight, for you to come and raise the defense of a game or of the assault having been committed during a sport, that game or sport must be played or done within the rules. You know, if you're asked to put on gloves and you don't put on gloves, then definitely that you would not succeed to raise that defense. So as you have seen in this case, court clearly held that a game which has been played by the parties and they didn't have the gloves on, the party who intended to rely on the defense of games and sports could not succeed. Let's now proceed to look at the third defense, and this is lawful correction. Now, for lawful correction, this is very common, especially with parents trying to raise up their kids. They may, punish them here or there, or give them certain punishments to try and raise them up properly. So in case such a kid went running to the police and brought up a criminal case against you for assault or assault occasioning actual bodily harm, then you could protect yourself under the defense of lawful correction. Authority for that position is in the case of Hopley. Hopley is a case of 1860, volume 2, F and F, 202 at 206. And in that case, judgment of Cockburn CJ, Cockburn CJ held that if lawful correction is immediate or in excess in its nature and administered for gratification of passion or rage, or if it's protracted beyond a child's powers of endurance, or with an instrument unfit for purpose and calculated to produce danger to life or limb, then it would be unlawful. So the whole test on the defense of lawful correction is that this punishment administered to this child or this person must be one, first of all, using the proper instruments. It has to be immediate, and then definitely it also must be intended to protect the child. But the moment you use excess force, you use instruments that damage the child, or you use or it's done for any other bad motive, then definitely you would not be successful under this defense. Let's now proceed to look at another defense known as necessity. It's also an offense that applies to these offenses against trespass to the person, and authority for the position, authority for the defense of necessity can be found in the case of F versus West Bankshire Health Authority. It's a case of 1989, volume 2, All England Law Reports, page 545 at 564. And basically in this case, court held that it's lawful for doctors to carry out operations which are in the best interest of patients where their consent can't be procured. For example, mentally unstable patients. So court went on to illustrate on that. And here when we talk of the defense of necessity, just to throw more light on it, what we mean is that a situation may arise where there is necessity and certain assault or some assault could be committed on a victim. This could also include, even apart from medical scenarios, it could also include circumstances where a person is being saved, or maybe their life is being saved, or property. And really this applies especially in terms of life and property. So in doing so, assault could be executed or applied onto a complainant. So the other party would be raising this defense of necessity in protection. Maybe they are trying to protect your property. Maybe you could be drowning, for example, and then they pick you from the water and trying to save you. They may assault you so that you are kept alive. So if you brought a cause of action, or if you brought a suit against such a person who assaulted you trying to save your life, such a person can rely on the defense of necessity, and as such, your claim would not succeed. Let's now proceed to look at another defense, which is the defense of self-defense. And the defense of self-defense basically is raised by a person who was trying to defend themselves, either their life or property, and in so doing they assaulted the other party or caused actual bodily harm on them. They would successfully raise this defense, and if they prove the elements of this defense, which we are going to be briefly looking at, then they would succeed under the same. Authority for this defense can be found in the case of James Owino versus Uganda. It's a case of 1977-54, where a court held that self-defense is an assault. It's a sufficient defense recognized by law where reasonable force was used. So here again, the rider, the qualifier is excess force. It's very important to note that for you to successfully plead this defense of self-defense, you must have used reasonable force, or the force must be proportionate to the attack. Very, very important. Also of interest is Section 15 of the Penal Code Act, which provides for that defense of self-defense. Then, interestingly, and lastly, let's look at the case of Uganda versus Omonyo. It's criminal session case number 61 of 2017. And in this case, court held that the defense of self-defense derives from Section 15 of the Penal Code Act, and that its ingredients included the following. So for you to successfully plead the defense of self-defense and you succeed, the court in Uganda has held that you have to satisfy these three ingredients, one being that the accused reasonably believed to be in danger. So if you're going to rely on this defense, you must have reasonably believed that indeed your life at that material time was in danger. Secondly, the accused reasonably believed in the use of force to avert that specific danger. So you must have believed that you had to use force and you had no any other option but to do that in that material time. And then lastly, the accused must have used reasonable force. This is really very important. So you cannot succeed under this defense if the force you applied to the attack was unreasonable. For example, if someone was trying to fight you and then you picked a gun and shot them in the head, even though you may actually be trying to defend yourself in the premises, but the force you're using is not proportionate to someone who is using their fist. But at least maybe if you picked up a piece of wood, or maybe you picked up any other item that is equivalent to the attack, then the defense would, in such a circumstance, suffice. So basically, thank you very much for listening in. That was all in today's class. Again, I encourage you to subscribe to my channel. Just click on the red button down there, just on the right hand screen of this video. Also share this video and like it. And you can also tell me which classes you'd want us to help guide you more on. But as we conclude this class, I just want to ensure and test whether indeed you have understood. And please, I'm going to give you a small exercise for you to brainstorm on and comment down and give me your answers, and I'll be letting you know who could be correct on the same. So the short exercise is that, is there actual bodily harm? And this is just a short, simple question. Is there actual bodily harm in a situation where, for example, a man breaks off his engagement, causing his fiancée to suffer depression, great depression? Can we say under the law that there has been assault occasioning actual bodily harm? So I need your answer, and please also tell me the reasons why you think so. So give me your answer, and then also give me the reason why down in the comment section, and I'll be able to reply you at any time, and to just test if indeed you have understood this class very well. So let's meet again next time. Thank you very much for being part of this class. See you. Bye-bye.